Hello there, and welcome again to the Disability Law Show. I'm John Scholes, your host. Not a lawyer, the lawyer's right there. That's the brains of the operation, Tamar Agopian from Samfiru, Tumarkin, LLP, stlawyers.ca. We'll tell you right off the top, always, how to reach out to Tamar and her team. Anytime you want to have that phone call on your own, a discussion won't cost you anything to pick up a phone and say, hey, what do I do about this, Tamar? 1-855-821-5900, help@disabilityrights.ca. I'll give you some other contact information throughout the show. And our main topic today will be 3 myths about disability claims. 3 myths about disability claims. That's coming up in just a little while, and some emails from you as well. But tomorrow, we always start off with the case of the day of the week that was. Pal, what do we got going on this week?
A really busy week, dealing with many phone calls that seem to have a theme, John. So I wanted to highlight this theme. And it's this idea that people are feeling pressured about returning back to work. And what I didn't enjoy about this theme is that it was impacting people that I spoke with across the country. So we work in various provinces, BC, Alberta, Ontario, and this is impacting men, women, people with different kinds of disabilities. One was a long COVID call that I had. One was on vestibular dysfunction. But what was common with all of these individuals that I spoke with was that they went through the process with the disability insurer. They were denied their disability claim, and those denials were maintained after appeal and appeal and appeal. And so this is why I wanted to highlight this at the top of our show, because it is somewhat intentional, folks. If you're in this process with the disability insurer, the process that they'd like you to go through is very much driven by the insurer. It's driven by the insurer because they are sending you the denial letter. They're saying to you, it's not severe enough. They're saying to you, there's not enough objective information. It's not things that we can see on a blood test or an x-ray, and therefore it must mean that it's not totally disabling. They say things like, but if you want to appeal and you want to submit more information to us to consider the disability claim, then by all means, why don't you send that over to us? You've got 30 days. If you don't send it to us in that time, we're going to close your file. We're not paying you any disability benefits, and they put the onus back on the claimant, who's already dealing with their health issues, by the way, to try and prove again and again that no, in fact, their doctors have put them off work and they should be entitled to disability benefits. What's frustrating about it, John, and what was common again with all of these claimants, was their disabilities were somewhat subjectively based, right? So they are complaints that they're making to their doctors, their symptoms that they have that are impacting their ability to work, and those symptoms are absolutely being validated by their practitioners, whether it be a doctor or a physiotherapist or a psychotherapist. But the insurance adjuster is disregarding all of this, and they're disregarding it in favor of saying, this is our policy, we're going to use this policy to deny claims, but we're going to say to you, if you want to stay in our process, continue to appeal. And what has happened with the individuals that I've spoke with, at least in the last few weeks, it's staggering to me. By the time they came to speak to us about whether there was a basis for a claim, and for many of them there is, if not all of them, they were so desperate financially that they said to me, Tamara, I can't stay off work. John, they're saying they cannot stay off work for financial reasons because they've been without any kind of income for months as they're trying to work through this whole process with the disability insurer. I had one situation where the woman said to me that she had been approved for short-term disability benefits, but kept having that door slammed when she was trying to transition to long-term. Again, appalling, because the test to qualify for both short-term and long-term is absolutely the same. So we see these ingredients repeatedly, regularly. Appeals that are not successful, subjective claims that are denied, people who feel the pressure to return back to work. And all I can encourage people to do is to please contact us early. It's okay to find out what your rights are with us, even before you get the denial letter. It's absolutely fine to find out, because you can see that if you wait too long to assert those legal rights, you may not have the option to even hire a lawyer. You have to feel that pressure to return back to work. By the by, that's not the right way to go. My advice is always to follow medical advice on whether or not you should work, but I can absolutely understand that financial pressure. And so hiring us, retaining us, we make it as simple as possible. Our consultations are also absolutely free. There are no upfront fees. We work exclusively on contingency. There are so many ways that we can help, But time is not always something that we can control. And John, this is why the appeal process is so frustrating, because it can take months, sometimes years, for people to complete that process. And then they assume, okay, now's the time that I should be calling a lawyer and fighting this. And I want to encourage people not to wait that long, because then the door may close on having those options, because you're just simply in a situation that, by the way, the insurer put you in. They want you in that situation. They don't want you to challenge their denial of benefits. They don't want you to hire a lawyer, because they know what's going to happen when we do. They cannot ignore our legal claim. They will be forced to come to the table to talk about resolving the claim. And just because they said to you, your symptoms are subjective and there's not enough objective evidence, we deal with that all of the time, because we leverage the court system in saying the courts have said these are valid disabilities, especially if they've qualified for short-term and are trying to transition to long-term. That makes the leverage against the insurer that much more significant. So maybe I'm sounding a bit like a broken record with these kinds of scenarios, but I thought it was just so staggering that it was one person after another saying, okay, I'm calling you now, Tamar, do I have a basis for a claim? I say to them, yes, and they say, well, I know it's going to take some months, but I can't even wait those months for you to work through the process. I think I've got to get back to work.
You know, it's funny, off the top, you said finally getting back to work, maybe 2024 now, and you've said, you know, there's no subjective evidence. This all smacks of possibly some of these being long COVID symptoms.
Yes.
And we already know from past shows that insurance companies have they've begun to really dig their heels in.
Big time.
Dig their heels in when it comes to long COVID, because if it gets all the way, as you mentioned, to court, where there's a decision that one or two of these things is legit, the floodgates could possibly open for these insurance companies, because a lot of people are sitting in the sidelines with long COVID symptoms. So the insurance companies say, no, 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 we don't pay for that, we don't pay for that, thinking this could be trouble if this eventually does come around. And it is. It's legitimate.
It's 100% legitimate.
Yep.
Just because it's not well understood by adjusters doesn't mean that it's not a legitimate disability, and one that supports that an individual with long COVID shouldn't be working in circumstances like that. And in fact, one of the individuals I had spoken with is a long COVID claimant.
There you go.
And he was approved for the full 2 years of the own occupation period. So the insurer had accepted, yes, these symptoms were sufficiently disabling, preventing him from going back and doing his job. I think he was some kind of a dispatcher for one of these warehousing units. Regardless, they accepted for 2 years that, you know, he couldn't work. And then as soon as the definition changed under his policy, as soon as it came time for the insurer to say, you know, look, we need to look at this and see if there's anything else that he can do, they evaluated his education, training, and experience. They evaluated these symptoms, which, by the way, had not resolved. They ignored his own doctors who were saying he still needs time, and issued the denial letter at the change of definition and said, you know what? We think you can work 28 hours a week, earning a fraction of your salary, and that's good enough, and we're going to cut off the claim. And so, you know, he really felt very much as though the rug was pulled from under him. He didn't understand the complete change in tune by the insurer on his long COVID claim, and why all of a sudden it was different for the any occupation analysis than it would have been for the own occupation. Right. And I said to him, it shouldn't be. In fact, it shouldn't be. Because if there's been an acceptance, then surely it's the same thinking around those two tests. I understand that the insurer intentionally sets the bar higher. It's arguably a tougher test. The earnings level is tougher to meet. I understand all of that. But if you look at the core issues of a disability that's long COVID, you've got symptoms where courts have accepted that in and of itself, this is disabling, like fatigue, like depression, let's say, like shortness of breath. So many common symptoms, right, with these COVID claimants, John. And so the insurers know that the highest courts in our land have accepted that these symptoms warrant paying disability benefits, and they do not want these things coming before the courts and having that first ruling from a judge saying long COVID is disabling. So I can assure you that those claims are going to resolve well before a trial, because the insurer doesn't want to stand up before a court and say, this is something that we did and that we're absolutely right in doing so. They are not correct, neither on the law nor the medical analysis. And this is the perfect recipe for us to, in fact, start these legal claims and get the compensation for these people that they deserve.
Again, familiar or otherwise to you, no problem. You can always reach out to Tamar and her team, right? 1-855-821-5900. You can also use this website, Tamar, you love it, pocketdisabilitylawyer.ca. It's free, it's anonymous. Tell me about it.
Yeah, so this has been conceived as sort of an add-on to the Pocket Employment Lawyer.
Right.
And the idea being that there's a really good and easy tool. There's drop-down menus that you can go into and figure out, do you have a basis for a claim for disability? What I like about it, there's a whole lots that I like about it, but the main thing I like about it is that it's a starting point for people to understand what their rights are for their disability claim, and that it is completely anonymous. So if you're sort of sheepish about actually speaking to one of us, someone on our team about your disability claim, but you want to get some quick advice, this is the place to go. The Pocket Disability Lawyer is a fantastic drop-down, easy-to-use tool for us for people to figure out what's what.
You can always send emails as well. We love getting your emails. That is help@disabilityrights.ca. First one for the show goes like this. Tamar from Ethan says, I'm a heart attack survivor, currently undergoing medical treatment. I've been on LTD for close to 2 years now. My family doctor has not cleared me to begin a rehab program and believes it's too aggressive, yet the insurer insists that I attend. Do I have to follow recommended treatments from the insurance company?
This is a tough one, Ethan, because, I want to say, no, you don't have to follow what the insurance company is telling you to do. And generally speaking, that's the advice that I give to everyone, John, is that they really need to follow the advice that they're getting from their doctors. But what's happening more carefully here is that the insurer is relying, most likely, on certain provisions in their policy that says, if we think you must, you must. And if you don't, we're going to cut off your claim. And so it puts individuals in this difficult situation where they feel that pressure. Just like I was talking at the top of the show, insurers use these policy terms. They call rehabilitation provisions, appropriate treatment provisions. There are sections in the policy that say that if the insurer assesses that you need certain kind of treatment or certain kind of rehabilitation, that they will push that through against the idea of cutting off the disability benefit. And so when you're in a situation like this, you always want to follow the advice your doctor is giving, 100%. But unless you and your doctor can establish that there's a medical reason why you cannot participate, perhaps it'll set you back in your therapy, perhaps it's premature for you to participate in this kind of rehab, you may be stuck with the reality of having to work this through with the disability insurer and playing it out as to where it leads. And John, you know where it's going to go. I mean, I know you've done enough of these shows to know. If the insurer is spending money in these kinds of assessments and treatment efforts, it usually is quite aggressive because they want to close the claim.
Want you off the books.
They want you off the books. That is their profit model. That is the way that this works. And it is a very common tactic. Actually, there's one insurer who will actually do a cost-benefit analysis. You'll see it in their claims file every time. Can we then spend, let's say, $5,000 on treatment or a rehab plan that will then shorten the duration of the disability claim by 6 months or a year? And they'll do the math on that. They'll look to see what the monthly disability benefit is, and if it's cheaper to actually force these kinds of rehab plans on people,
off you go.
Off you go. And they will try and do that and sort of pigeonhole this, because either way, they're spending less money and they're getting you off claim. They are not looking at your health issues as the primary. They're not interested in that. They are interested in getting that closure and justifying in their file and pursuant to their policy that they don't have to continue paying the LTD benefit.
Good opener. We'll take a short break, guys. We got lots more. 3 minutes about disability claims is coming up. In the meantime, anytime you want to reach Tamar by phone, 1-855-821-5900. help@disabilityrights.ca is that email address. Lots more. The Disability Law Show is on the way. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Disability Law Show. Tamar Agopian, always reachable, and her team as well. Phone number may be the first stop, 1-855-821-5900. You prefer email, help@disabilityrights.ca. The main topic for the show today, Tamar, as you know, 3 myths about disability claims. Number 1 goes just like this. I love this one, only an insurance company can determine whether you are disabled or unable to work. Really?
No, of course, no. Of course it's a myth.
Yeah.
But insurers are the gatekeepers of their policies,
Yeah.
okay, John? And so, as I said to our viewers, moments ago, they will use the policy as a way to try and prevent people from getting on claim and getting those benefits. And so, can they determine who's disabled? Yeah, absolutely they can determine, because they've set the policy, they've set the words,
Right.
they've sort of done some loose training of their adjusters, and they're the ones who are going to say whether you're going to be approved or not. But at the end of the day, the real determination is made by you with your own practitioners. So you want to go to your doctor, you want to go to your psychologist, your physiotherapist, your nurse practitioner, whoever it is that is your primary caregiver, or 2 or 3, you want to have that discussion with them about, look, is it sustainable for me to continue working? Does it make sense with all of the health issues that I have? What do you recommend, doctor, nurse practitioner, so on, in pulling me off of work and then pursuing this disability benefit? Because that really is the idea behind these disability claims, right, John, is that if the doctor is supporting that you cannot work, that absolutely is the basis to get LTD benefits, despite the fact that an insurer will want you to understand otherwise or think otherwise. And I cannot stress this enough. When you receive that denial letter, please do not accept this, folks. Don't accept what it says, because you know your doctor's already approved that you should not be working. And this is the prime opportunity that insurers want you to capitulate. You should be contacting a lawyer. Find out what your rights are. Find out if there is enough evidence, enough support there to move the needle with the disability insurer with our help, because by all means, these are the kinds of claims that we get involved in day in and day out.
Disability myth claim number 2, a denial of a disability claim cannot be challenged and must be accepted, Tamar.
I'm rolling my eyes,
I know.
Irritatingly rolling my eyes, because this is the one myth that is the most frustrating, because people do walk away, John. The statistics on the number of people who accept the denial of benefits is staggering, which is why insurers have record-breaking profits. This model works, is that when you receive that no, and that no is pages of information in a letter that some of my clients don't even understand what's in there.
Most of it, imagine.
Most, exactly, because it's a bunch of legal speak and policy terms, and you really don't get it.
It's a big bad insurance company, how would they not know? Right?
And you think that that's the end of the line
Yep.
for you, when it absolutely is not, which is why we've set up the model that we have, which is free consults and working on contingency for people, because we know that once they don't have that financial support from the disability insurer, the last thing they want to hear is, hey, I'm going to send you a bill every month for all the hours I'm going to work and advocate and do the things that I need to do with the insurer. It's a recipe for success, but the starting point has to be the claimant saying, I'm not going to accept what the insurer wants me to believe, which is that I don't have a valid disability claim.
Third myth of the 3 about disability claims goes like this, guys. Says appealing a denied claim is the only I love these. Appealing a denied claim is the only way to get your benefits or compensation.
Oh boy.
Only way not to
It is a process that's meant to frustrate.
Yep.
Okay? It's a process that's meant to be long, hard, and putting more pressure on you as a claimant to show the insurance company, no, I'm really sick. No, I'm really, really sick. Here's another report from my doctor. By the way, I had to pay $200 out of pocket for that report from my doctor to demonstrate to you folks at the insurance company that this is a valid disability claim and I shouldn't be working. What I don't like about the appeal process is that it is mired in the lack of transparency. What does that mean? The insurers are not being very clear or honest or upfront about this process. It's not in the disability policy, I can assure you. They don't even explain to you whether or not someone else is going to review the claim that has already been reviewed. They don't even share with you whether they're actually going to get a medical doctor to weigh in, do a review of some kind. They have no checks and balances in most of these insurers, if not all, to actually make the process meaningful and actually tell people, yeah, you know what, you've got a legit shot in actually getting this claim approved in the appeal process. It's just simply this way of running down the time to frustrate people, running down the time to start that legal claim and really find out what your rights are. And so myth number 3 is a big one, John, is that if people don't take that step of actually finding out whether they've got a basis for a legal claim and start their process early, they will lose that opportunity for the disability benefit.
And there's a high probability that that appeal process won't happen just once. They'll keep doing it. I know you and James have seen 4 or 5 times people have gone through that process and they're just banging their head against the wall.
It's brutal for that exact reason, that there is no end in sight. Some insurers will say sort of 3 kicks at the can and you're out, and then we're closing your file. Well, even that alone, so now you've gone through 3 appeals, they've said they've closed your file, well, you just assume that there's no other avenue. You won't really even know until you get to the back page of page 5 or 6 in your denial letter, where they say right in the bottom, small print, and if you're going to start a legal claim, you've got 2 years to do it. Okay?
That has to be there.
It has to be there.
Wow.
In most of the jurisdictions we work in, there's an Insurance Act provision that says they have to tell you what the limitation period is. But of course, they're not going to put that front and center in their letter. They'll put it way in the back when you've already got the rejection in line 2. How many people, it's human nature. You're not going to go to the back of the letter and think, oh yeah, okay, maybe I should be calling a lawyer in a situation like this. And they want that. That works for their model, for them. And what I'm trying to encourage individuals to do, like our whole team, is that there are other choices. And one of the most efficient and effective ways to get your benefits approved is starting that legal claim. Otherwise, you're just leaving money on the table.
And with that, we'll take one more short break, get into a couple of emails, and go to the website, mydisabilityquestions.com. For a question, you can use that anytime you would like. And the phone number, always maybe your first line of defense against the insurance company. Call Tamar, 1-855-821-5900. And we continue with more of the Disability Law Show. Hang in there. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Disability Law Show. Good to have you back with us. I mentioned just before the break a website called mydisabilityquestions.com. That's for you to use. It was designed for you to ask your questions on your tablet, your smartphone, your desktop for that matter. It's free, it's anonymous, and it's got a searchable database, meaning that maybe a question similar or possibly precisely like yours has been asked and answered in the past. If not, you can use that feature. Send along your question. It will get answered by Tamar or a member of her team. Today, it's going to be Bethany, writes in from mydisabilityquestions.com. Tamar says, I was on long-term disability for over a year before I attempted a return to work in my office. I was successful for 2 weeks, but then began having debilitating panic and anxiety attacks. My doctor wants me to go back on leave, but my insurance company says I'm now able to work and won't resume benefits. What do I do now?
This is a really difficult situation because theoretically, John, she should be able to go back on claim. There is a section in the policy, every disability policy has this, which is called the recurrence provision or some other, interrupted periods of disability. So this kind of provision theoretically works exactly in the kinds of situations that Bethany is in, is that you might want to be attempting a return to work, you get the medical clearance to try it, and your health issues persist again, putting you off work once more. The key to these kinds of situations, though, is the medical support. She really does want her doctor to substantiate, to support, to put a report together that explains, look, we gave it a go, her symptoms are still persisting, the return to work was premature, I'm pulling her off work for these following reasons, here's what we're submitting to the insurance company for reconsideration. It should, in theory, be that straightforward. But if the insurer has an opportunity to cut off, which they've done, and resist the return, which they do, then they are going to maintain that Bethany is simply not sick enough, not disabled enough, not to continue the return to work process. The challenge becomes, what do you do in a circumstance like this when your doctor is supporting it and the insurance company is sort of closing that door and closing that door? This is prime for a legal claim. I'm actually representing someone right now where she was on claim for a number of years, finally got the sign off to return back to work. Same situation as Bethany, maybe lasted about a month, and then went off work again. And she came to me and she said, look, the insurer wants me to appeal, the insurer wants me to do all these things, these typical tactics, and I just don't think that I really want to go through this process with the insurer. And I said, you absolutely should not. You should not go through the process with the insurer, because if you can pursue your rights through a legal claim, when you've got a legal argument where the policy is in your favor, the policy says that you can absolutely access insurance claim benefits again, without having to go through the waiting period, John. You don't have to go through that whole, 3 months,
whatever it is, yeah.
Exactly. It's a 3 to 6 month waiting period. Then why shouldn't you be back on claim? And so this is a situation where I don't expect the insurer will move that needle for Bethany, regardless of what information she submits. They obviously had her on claim for a while, and she tells us it was about a year. And so maybe they just don't want her past the 2-year mark. I mean, who knows what's informing that decision? But when you've got these kinds of policies that can work in your favor, this is a prime opportunity to assert those legal rights.
Let's get to Jennifer. We'll wrap up the show with Jennifer's email. It says, I'm on LTD for ongoing chronic pain. My group policy has a 1-year change of definition provision, which will be coming up in a few months. I was told by the insurer that my LTD is approved past the change in definition date, but wasn't specific. Is there anything I need to do now to protect myself?
So, again, just as we were talking about, this change of definition is a very critical point in time for insurers, right? Because the onus is on them legally to demonstrate that there is other work that you can do and that whether or not you're still entitled to LTD. And it looks like from Jennifer's situation that that change in definition is actually at the 12-month mark. Most policies are at the 24-month mark. Either way, though, these change in tests are the same, that what you need to establish is the same. What I don't like in what Jennifer describes to us is that she hasn't really been given anything firm about the fact that she's been approved past that change of definition. And so how do you protect yourself in a situation like this? Well, Jennifer, you want to get it in writing. I mean, this seems trite, right, John? I mean, lawyers say this all the time, paperwork is king. It is. You really want to get the insurer, if they've approved you past that change of definition, to put that in writing to you and explain that to you. Because then it becomes that much harder, legally speaking, for them to cut you off down the road. I mean, they may, but if they're going to do that, they have to justify doing that. So this casual conversation over the phone, not good enough from my perspective. It leaves too much to chance. I would much prefer to see Jennifer have that letter in place and also obviously have that medical support that she's still disabled from any occupation.
And if she's got the physical wherewithal, just, take some quick notes during the conversation. It doesn't have to be word for like a court reporter, but have some basic notes of what the conversation was, even record it if you want to between two people, so you can go back and use it and send them an email saying, hey, here's what was said, just to make sure you guys realize I'm on the ball, right?
Exactly. And so the recording is key. And you can send an email, right? Jennifer can just send an email back to the adjuster saying, hey,
here's what we talked about.
Here's what we talked about.
Got it. We are just about done for another show. Thank you so much for tuning in. Anytime you want to use our resources to get a hold of Tamar, you can. Again, that was help@disabilityrights.ca. That was the email. Before that, mydisabilityquestions.com. You can use that one. Free and anonymous right there. Searchable database, as I mentioned. And then the phone number. Call. Won't cost you anything to have a chat with Tamar and her team. 1-855-821-5900. Again, 1-855-821-5900. Thank you so much. If you contributed, lots more in the next show, so stay tuned for that. And we'll be back with the next edition of the Disability Law Show. Enjoy the rest of your weekend.